my lord, with regard to the matters relating to, my lord, the sale of some of,
Yes.
yes, my lord, lordship had passed an order on 13 June, my lord. We have received it, my lord. There are small two corrections, my lord. Name has gone down wrongly. We have pointed out and
Make it correction.
we have done it.
Come for correction.
Yes, my lord. Only thing, my lord, it may come.
You keep it with you. It will come tomorrow for correction. Then make it. Then give a copy.
Very well, very well. Let it appear as to be mentioned. It was due to appear, my lord, on 20th. But tomorrow, if the correction can be made, my lord, then compliance can be shown on 20th. Tomorrow has to be mentioned, my lord. Great.
May I mention, my lord, what matter now? CS 316 of 2010. Lordship was fixed the matter on 17th for argument. But 17 is holidays.
Was holiday.
Was holiday. But today is not fixed. My lord, kindly fix the matter in any time. Fix the order, my lord. Good morning. Yeah.
21?
21.
Friday.
My lord, may I have a leave to file
Part heard matter. Possibly part heard argument শুনেছি আমি। Argument has not yet to begin. So it is not part heard matter.
No, it is not a part. But
Then it will go to the court. To the determination. Court has determination. Now this court has no determination right now.
my lord, may I have leave to file, may I lordship leave to file my written statement in the department. It has come from Jabalpur, my lord, duly notarized, my lord.
Is it within time?
Yes, my lord.
Who is for the plaintiff?
My lord, plaintiff, Mr. Alam.
Come tomorrow. It will come tomorrow. It will come in the list tomorrow.
It will appear tomorrow.
Yeah.
I have my lord's kind leave to mention a matter, my lord. I'm humbled that I've been appointed as a commissioner, my lord, by your lordship. That only
Fix it tomorrow. Tomorrow, Mr. Bag, tomorrow it will come. I will pass order.
I'm very deeply obliged, my lord. I'm only praying, my lord, if because of
Day
prior
after tomorrow, not
professional
tomorrow, day after tomorrow.
commitments, my lord, if a better suited person be appointed, my lord. I'm very, very deeply obliged. Deeply obliged.
Commercial division matters, new motion, item number 1.
I appear on behalf of the
I
plaintiff.
appear for the defendant.
Lordship will recall this is the matter wherein your lordship was first pleased to transfer it to the commercial division, whereafter your lordship division bench's order was shown to your lordship that to transfer it to the commercial division. Lordship, thereafter we had sought for a clarification, which the honorable your lordship, with your lordship's kindly by being led by Mr. Jishnu Chaudhary.
There was an order of the division bench which said this was a commercial suit. Milord, apropos that, Milord, the suit was marked, Milord, as a commercial suit. Now, Milord, after that we came and Milord indicated to your lordship that because of the subject matter, it can never be a commercial suit. Your lordship, Milord, felt that in view of the division bench order, it is only appropriate. Though, Milord, it's just an observation towards the end of the order, without, Milord, considering the reason.
I cannot contradict that.
Yes. So, Milord, we went up and filed an application before the division bench, and we, Milord, indicated that this is something which has to be decided. The division bench, Milord, has clarified the order and had sent the issue back to your lordship, Milord, to decide. Because really speaking, the division bench did not decide the issue. Just
So that is enough. The division bench say, I will decide this issue.
Order, Milord, may I just hand up to your lordship?
But in that case, it will not remain in this court.
No, your lordship has to decide, Milord, whether it's a commercial suit or not a commercial suit.
That is separate issue, but I have no determination of 2009 matters.
Oh. Lord, I am singularly
Appropriate bench can decide on this because it is neither part heard.
No, but if it's part heard, your lordship can decide the matter.
Not possibly part heard.
Part heard?
No, sir, it's not.
Not part heard. So then, Milord, we shall have to.
Yes. Oh. It was hard in part.
But in part, then your lordship can decide. Lord, please see
Who is the
order.
plaintiff?
Lord, I
I'm
for
the
the defendant. Lord,
I'm
he's
the
for the
plaintiff.
plaintiff.
You are
I'm for the defendant.
Lord, please see the order, my lord.
just a minute. Let me go through this order.
Proceed. दादा क्या बोले ना बोले बोले
It. So your point is it is not commercial.
Yes, my lord. My lord, would your
Where is
lordship
the
be
plaint?
pleased to, my lord, take the plaint once? টটের বইটা কোথায়? ভুলে গেছে আনতে বইটা। চোখেছে আছে? হ্যাঁ না ঘাটলি না ক্লার্কের would you, if your lordship is pleased to take my plaint, from paragraph 1, my lord, I'll very quickly, my lord, tell your lordship.
From paragraph?
1, my lord, I'll quickly tell your lordship, I am a lessee in respect of a property. I'm in possession. Now, my lord, this is in terms of a compromise decree in this suit. And, my lord, an intention of lease. That's my lord, paragraph 2. Now, my defendant number 2, my learned friend's client was interested to take the property on sublease. And, my lord, they approached. There were, my lord, negotiations. A sublease deed was finalized. It was prepared. They made over the stamp duty to us. We prepared the document. And, my lord, if your lordship kindly sees, we went to execute the document. On the last date, the my lord backed out by contending, my lord, that I didn't have title to the property. So, my lord, two things, my lord, happened. Number one is, he, my lord, by acting in such manner, has acted in breach of contract to enter into a sublease. Secondly, he's also, my lord, slandered my title to the property. Slander of title, my lord, is a tort for which I am entitled to damages. So this is not exclusively a commercial matter. It's 50% commercial, 50% not tort. I'm sorry, 50% contractual, 50% tort. Now the contractual part of it would also not come within the ambit of a commercial suit because this was not exclusive.
There was no agreement between you and the plaintiff, between the defendant.
There was a memorandum of understanding.
But no agreement was signed.
No, lease deed wasn't, my lord. Please see, my lord, paragraph 11. 10, my lord, is defendant number 2, pursuant to the MOU, my lord, nominated the defendant number 1. But the MOU is, my lord, indicated in paragraph 4. On 3rd March 2008, a memorandum of understanding was executed by the plaintiff and the defendant number 2, by which the plaintiff agreed to devise the said premises on lease to the defendant number 2 on the terms and conditions. So, my lord, this was the agreement to enter. It's an agreement to enter into a lease, a sublease. Then, my lord, ultimately, despite the fact that we were ready and
So
willing.
that means even if it was for commercial purpose, that is a future commercial purpose.
Correct. Correct. And future, not exclusively commercial. Future purpose is also residential come commercial.
No, future use, it is strictly barred by Amadal Sarabhai's case.
Yes. And pilot present purpose is pilot not commercial plus 50% of the case is based
I'm
on
not forming any opinion here right now, but it appears to me. I have to go through the plan, then I can decide. And I have to hear the other side also. Yes.
Maybe come back on another day, Miller. Maybe come back on another date, Miller.
Then I'll also prepare a short note for your lordship's convenience.
Very single point.
Single point. Just pilot explaining the plaint and my lord, the paragraphs which has my claims.
This is GA8.
Yes, lord.
GA8 is for
No, that's the recalling application that they've taken up.
My lord, the time we spent,
31st January was the order where it was transferred.
Yes.
my lord.
so my lord, the time we spent doing this, we could have proceeded with the suit and almost got a degree. If my learned friends would agree.
No, my lord, because the
Conversely,
division
my lord,
bench's order
If
was.
my lord, we continue as a commercial suit while
Look,
it's
one thing. You are defendant.
Yes, my
You
lord.
have to file WS.
My lord, we filed.
You have filed that.
they filed WS, they filed a counterclaim. I have filed my lord, my
Alright.
written statement, suit is
Part
ready.
GA8 of 2023 in part. When you'll be able to come next?
My lord, any day, my lord, tomorrow, day after.
28th June.
We'll come back.
Fixed 28th June for further hearing.
Grateful.
I'm grateful.
Madam, appends 11. Regular division matters to be mentioned. Item number 1.
Same thing.
Yes, my lord, it is with regard to the Chatterjee International matter. My lord, upon an application filed by the joint administrators, your lordship was pleased to direct them to publish a notification with regard to the occupiers, my lord, bringing forth their documents. My lord, your lordship on the last occasion had allowed prayer A. And my lord, this publication was to be made by the 12th of June. My lord, then
Extended, my
the
lord.
time is to be extended for a period of 5 weeks, my lord. 3 daily newspapers are involved. And my lord,
It's not part-heard matter.
yes, my lord, it is. Your lordship has been pleased.
No, I have not made it
No, no, my lord,
part-heard.
Not formally part-heard, but my lord, your lordship has been pleased to pass this order, and my lord, there is no party, my lord, who are aggrieved and who are in any way, my lord, in any way opposing this.
Publication is done.
My lord, the notice has already been settled by the registrar. My lord, for the publication, some 4 or 5 weeks more time is required.
On
Only-
prayer of Mr. Ghosh, the learned counsel appearing for
The joint administrator.
the joint administrator, time is extended by 4 weeks for making publication in terms of order dated 10th April 2024. Fix 5th July.
5th
No, not,
July.
that will not cover.
will not cover.
29 July. No, not 29 July.
Lordship can keep it after 4 weeks, not subject to the court's convenience, my lord. 3 weeks lordship has given them, and 1 week, my lord.
23rd July.
As your lordship,
23rd July
your lordship will kindly formally keep it as part-heard. Your lordship has heard the matter.
for further order.
Gratefulness.
My lord, if your lordship only makes an observation,
For
heard in
further
part,
order.
For
As
further
your-
order,
that
that means part heard.
that will deeply obliged.
My lord, kindly record, my lord, my presence, my lord, otherwise.
Give it.
Lordship.
Item number 2.
Relating to that Charushila trust estate, my lordship knows
I
my lord
appear
has
for the-
throughout heard the matter, my lord. Now we have come with an application, my lord. Only the residue part is due, if I can say. My lordship has appointed the receiver, specifically directing it to be a stopgap, a temporary measure, because the main motto of all of us is to form the committee of
Formation
management,
of the
and only that part is due. On the last occasion, when the matter was mentioned, lordship, we had to satisfy lordship that why my lord wanted to release the matter. Then, my lord, we had tried to satisfy your lordship, my lord, that only this part is due. Entire matter was heard. My lord, if your lordship kindly come to it, application ta din na.
GA 15, my lord.
My lord, yes, my lord. Page 90, my lord, lordship will find since 2017, my lord, this attempt is made by the honorable court, and even then also as a
Page
90, my lord. Lordship will find, my lord, of the trust, Justice Sen, when was taking the matter, my lord directed the publication, because the main motto or the motive was to form the committee of management for a permanent solution and proper administration of the trust. The petition
you
number 1,
suggest the names.
my lord, yes, my lord, we have already, my lord. But
Paragraph 25.
yes, my lord. Oh, Mr. Dasgupta is also there. Paragraph 25.
What happened to you?
But he's for petition number 1.
My lord, I am for petitioner number 1.
What happened to you?
Reach. I think I could not reach.
No, you are in the High Court itself. I understand you are in the High Court itself.
I am in the High Court. I am in the High Court and I could not reach.
Could not reach.
So you suggest the names.
Yes, my lord.
Have you suggested?
Yes, my paragraph 25
Yes,
as Mr.
paragraph
Dasgupta.
25.
But I believe 5 names because the trust wanted always the 5 names to be suggested and no one, no female trustee should be there. But one name, as I find, I am duty bound to point out to your lordship, name number C, Sushmita Rai should not be. My lord, in that case, might allow me to come back day after tomorrow with proper 5 names. We will like to suggest to your lordship.
Heard in part, adjourned to 27 June.
Deeply obliged, my lord.
Deeply obliged.
Grateful, your lord.
Grateful to you.
Item number 3.
None appears. Adjourned to 21st June.
Item number 4.
Pass over, Rakhu.
Also,
Specially assigned matters. Item number 5.
5 to 9 হবে.
5 to 9.
Fellowship 5 in item number 8, I appear for the defendant number 79. Fellowship, there's a partition suit. Injunction order has been refused to the plaintiff. Your lordship has directed we have filed an order 7 rule 11 saying that this is barred by law and no cause of action. On 3rd of May 2024, directions were given for filing affidavits to the plaintiff. No affidavit in opposition has been filed to my application under order 7 rule 11. Today the plaintiff is not appearing. So your lordship, the time
Today I cannot pass any adverse order.
adverse order, your lordship, either the time has to be extended or your lordship will keep it on any other date. Tomorrow, day after tomorrow, your lordship will keep it.
None appears for you are for the
my lord,
plaintiff.
Defendant number 79. Defendant number
My lord, I
79 in
appear for
item number 8.
I appear for defendant number, my lord, 2.
Who is the plaintiff?
Plaintiff Manju Agarwal was appearing. She was
None
appearing the
appears
last
for the
Saturday.
plaintiff.
My lord, GA1, I was seeking an extension to put in the affidavit.
I appear for defendant number
Granted
79.
counsels for the defendant. Some of the defendants are present. Time is extended to file affidavit in opposition in GA1 of 24 by another 2 weeks. Reply is to be filed within 1 week thereafter.
Your lordship, in respect of applications, order 7 rule 11 applications where affidavits has not been filed, your lordship can keep it for hearing because they have failed in their timeline. The plaintiffs have failed.
এইভাবে লিখুন, exchange of affidavits in GA1 of 24, 2 of 24, 3 of 24, 4 of 24 and 5 of 24 are yet to be done. None appears for the plaintiff. Time for file affidavit in opposition is extended by 2 weeks. Affidavit in reply shall be filed within 2 weeks thereafter. The matter will appear in the list on 26 July.
Your lordship, in GA4 as well, they have not filed their opposition.
My lord,
GA4.
instead of 2 weeks, my lord,
GA4 as
3 weeks, my lord. It's a, my lord, voluminous, my lord, records, my lord.
তাহলে ওটা 3 weeks করে দাও আর ডেট হচ্ছে
3 weeks, 1 week, and thereafter, my lord, any day after 4 weeks.
16th August.
Grateful.
Your
my lord.
lordship will kindly record GA4 as well. In my application,
Yes,
also,
I have
they have not
mentioned that.
filed.
I have mentioned that. All the years. Today I cannot pass any adverse order.
I understand. Grateful.
I cannot pass any adverse order today.
Grateful.
The request is, my lord, for 19th August. No, 19th August. I mean,
20th, 20th.
20 তারিখ যদি হয়।
20th August.
20th.
20th August.
Grateful.
Grateful.
20th
2 weeks.
Grateful.
Item number 10.
I have heard it in part. Where is your other side?
Milord, Mr. Mitra is there, Milord. He wants to do the matter today. Milord, we filed an application.
This G7. This is
Yes, Milord.
G7.
Under section 10 of the Civil Procedure Code, Milord, and section 151.
In view of?
In view of, Milord, an earlier company law board proceeding, and in view of a prior
APO
suit.
210 and APO 211.
Yes, Milord. And Milord, in having regard to a prior suit also. So two Milord proceedings. One is before company law board, which culminated in a final order pending appeal in Milord before this honorable court. Two is Milord, a suit filed before the Uluberia court.
APO?
No, APO is the section 10F appeal.
Yes.
And Milord, that's Milord, APO 10 and APO 11 are pending.
You have not mentioned anything about Uluberia court?
That's Milord in the supplementary affidavit.
Where have you mentioned that?
Yes, Milord, supplementary affidavit. Milord, I'll just indicate, Milord.
TS 13 of 19.
Yes, Milord. Before the Uluberia, but the main
Just
thrust.
senior division.
Yes, Milord. The main thrust, Milord. I'll just show the supplementary affidavit. Paragraph 4, Milord. And annexure I is the plaint.
TS 111 of 2007 Civil Judge Junior Division.
Yes, Milord.
And the other is
Milord,
TS 13 of 19 in Uluberia before Senior Division.
yes, that is the one, Milord. That is, Milord, at page 68 of the supplementary affidavit. Milord, the reliefs claimed, Milord, your lordship would find the rather large plaint. Milord, page 105. Declaration and injunction in respect of a property at Uluberia.
And where is this plaint of TS 111? TS 13?
TS 13, Milord, plaint is after that, annexure J. That your lordship would, Milord, I'm sorry, Milord. Kindly give me 1 minute, Milord. I is, Milord, page 68. And J, Milord, is at page being able to find it. I think by mistake, there is a written statement, Milord, annexed.
Yes, written statement is annexed.
Yes. I'm sorry, Milord, that I'll, Milord, correct it. Now, Milord, the main issue, if you to remind your lordship, Milord, is
No, this is written statement in 111 of 2007. But nothing of TS 13 of 19.
no, Milord, that's the mistake committed.
Data pleadings of 111 of 2007 are there.
Yes.
But so far as the other suit is concerned, it is not there.
Main proceeding, Milord, is the company law board proceeding. If your lordship takes the petition once, But kindly see, my lord, page 168. This is the central issue.
সেকেন্ড ভলিউমটা কোথায়?
68 to the page 168 is a family settlement. The 29th of September 2002. Lordship will see the names, my lord. MM Kejriwal, Dr. VK Kejriwal, RK and MK. MM, my lord, is the father. Page 168. MM is the father. VK, my lord, is the father's brother.
So family settlement referred to you by in page 6.
Yes, is page 168.
Sorry, paragraph 6. Petitioner state that under the family settlement so and so,
Yes.
this family settlement is in page 168.
168. Or, my lord, page 175. Same document. Now,
What is 175?
170, same document, my lord. Now
What is the difference?
no, there's no difference, my lord. It's a better copy, my lord. There's no difference. Now, my lord, RK is Ramesh. MK is Mahesh. My lord, I am for Ramesh. And my learned friends are for Mahesh.
You do one thing, come with a short notes of arguments stating the brief fact. Along with, if you want to rely on some judgments and law points, come with that. But at the same time, you have to file a supplementary affidavit for this one.
To correct that and bring on record the plaint.
That is TS 13 possibly.
ভুল করেছে অনুরাগ written statement লাগিয়ে দিয়েছে. My lord, I'll do that, my lord.
Well, my learned friend is, my lord, moving this application under section 10. That
And
is, my lord,
151.
well, he proceeds on section 10. That is what he has written in his petition. Well, section 10 cannot lie, with the greatest respect, because there must be two, my lord, suits. One prior suit, one subsequent suit, my lord, which ultimately, my lord, talk about the same thing. The issues will be the same, parties will be the same, the cause of action will be the same. But, my lord, here my learned friend is talking about a proceeding before the company law board, which has, my lord, ultimately matured into an order.
He referred to two suits also.
Yes. No, my lord. So far as, my lord, my learned friend's emphasis now is, well, he says that, my lord, there's identity of the cause of action in the matter filed before the company law board and before, my lord, in the suit. Now, my lord, today he says, my lord, therefore, that the 10F appeal, which is, my lord, now under consideration by this honorable court, the subject matter is, my lord, identical or, my lord, similar to the subject matter of the concerned suit, Uluberia suit. Now, my lord, with the greatest respect, if my learned friend is moving under section 10, the language of section 10 is very clear. It is only when, my lord, there are two suits. My lord, one of
Other proceedings.
That's right. No, my lord, the language it says, no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties.
Suit.
Yes.
Your point is that this must be a suit.
Yes.
But he is referring to two suits others instituted in Uluberia.
Yes, my lord, but, my lord, he ultimately, my lord, says there are two suits.
Completed.
All right, I will hear you. Let him come with the notes
Very well.
and with supplementary affidavit.
Very well.
Hard in part, adjourned to
Heard.
28 June.
Grateful.
Because voluminous documents are there, you make a short, precise statement of facts.
28. Adjourn motion, item number 11.
Your Lordship, my senior is appearing for the respondents of item number 11 and petitioner for the item number 12, Your Lordship. She is not appearing today, Your Lordship. She is out of station for personal grounds, Your Lordship. Praying for her not this week.
Very good. You raised one point last day, that is the revocation part.
My point was, by the modification made amounts virtually to an alteration of a bequest made in the will, whether that would be permissible.
We can hear it on this maintainability issue.
But that order, your lordship, has already passed. I have
Yes.
advised my client to take out an appeal against that, because that has to be set aside if at all in appeal. But I shall argue the matter because their application really now survives. It is one for removal, my removal. So we'll see whether it comes even within that.
It depends on outcome of the appeal.
Yes, it will, my lord. So keep this, my lord, after a month, my lord, we'll see.
On prayer of the learned counsel for
Respondent of 11 and petitioner of item number 12, your lordship. GA 17 and GA 18.
give a slip. The matter is adjourned to
And your lordship, there is no Vokalatnama has been filed yet.
25th July.
I have seen the status. There is no Vokalatnama in the status.
I think it should take a little bit time for appeal, disposal of appeal. So I'm fixing it in August.
Yes. It will be
22nd August.
Go and check.
22nd
In the
August.
status actually.
Vakalatnama has been filed. I don't appear without a Vakalatnama on record.
Raghu? Chamber application for final disposal, item number 13.
I appear for the defendant, my lord. We made this application for rejection of the plaint on the ground of section
Mr.
430.
Mishru is to be
Yes, my lord.
is to submit.
Lordship had asked me last occasion to bring the compilation of judgments and to prepare a short note also. Notes are good. Lordship, may I hand up and I will. The notes. Would you give that a copy? Well, I'll give you any notes to give. Any notes give. Because I've given copy of the judgments.
Of the judgments.
So I've given the notes only.
Very well. Apart from those judgments, there are no other new. Very well.
But you kindly take the notes first. Admitted fact says that suit was filed in 2007. And the suit encompasses disputes between two brothers. Plaintiff number 2 and defendant number 4. They are members of the Jhunjhunwala family. Now, the suit involves one property, paragraph 2, at Bright Street, where Bishwanath Jhunjhunwala used to reside. And after his demise, their 2 sons reside. Now, there was a family settlement. And on account of non-implementation of the family settlement, disputes arose. It is in this factual background the suit was filed. Now, kindly come to Roman 2, page 3. The present application by the defendant is for rejection of plaint. This application is filed in 2023. And dismissal of suit filed in the year 2007. On the sole ground that section 430 of the Companies Act, which comes into force on June 1, 2016, excludes the jurisdiction of civil courts to entertain suits in respect of matters which the NCLT is empowered to determine under the Companies Act. Or can you see section 430 as is quoted below? No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the tribunal or the appellate tribunal is empowered to determine by or under this act or any other law for the time being in force, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this court or any other law for the time being enforced by the tribunal or the appellate tribunal.
Yes.
Now, paragraph 6, page 4. Section 430, for having retrospective effect, would have had to be expressly retrospective. That is not the case with 430. The mere use of the word entertain does not make the section retrospective, especially since 430 is not a procedural provision, but a substantive provision on the ouster of jurisdiction of civil courts. For the proposition that section 430 is not a procedural provision, but a substantive provision, reference is made to Unnikrishna's case. Hey, bold code that should that is Bombay High Court, 19 SCC Online Bombay. That section 430 does not affect or apply to pending suits has also been held in Unnikrishnan Nambiar versus official liquidator. It's Kathawala's judgment. Paragraph 9. Mere use of the word entertain does not make substantive provision of law retrospective, especially when it relates to jurisdiction of court. Smithies, it should be SMITHIES. Smithies case at pages 319 and 320 and K. Capenchaco. I am reading out from the Capenchaco 76 Supreme Court, paragraph 40, which is self-explanatory. Again, in Smithies versus National Association, Section 4 of the Trade Disputes Act 1906, which enacted that an action for tort against a trade union shall not be entertained by any court, was held not to prevent the courts from hearing and giving judgments in actions of that kind begun before the passing of the Act. It is a general rule that the legislature alters the rights of parties by taking away or conferring any right of action, its enactments, unless in express terms the law applied to pending actions do not affect them. But there is an exception to this rule, namely, where enactments merely affect procedure and do not extend to rights of parties should be. In Joseph Sucha and Company, 1875.
Number of Supreme Court judgments are there on this point.
Yes. Malak?
Number of Supreme Court judgments.
Just because the word entertain is used, unless it is So I've quoted this one of them, 76 Supreme Court.
To what extent Section 399 applies? To what extent Section 399 applies?
399 of the Companies Act. 399 of the Companies Act 56 would have been there. That was regarding 10% qualification shares.
Is it applicable here?
No, because Companies Act 56 was repealed by the 2013 Act. It is not the case of the defendant that the Companies Act 56 ousted the civil court's jurisdiction, because there was no section equivalent to Section 430. So 399, 397, 398 will have no application, because that was held in Asansol Electric, our High Court, 76 or 74 Calcutta, and down the line.
One thing you must clarify.
Yes.
What is the extent of shareholding of the plaintiff?
I'll
if it falls below 10%, then there is no remedy before company law board, previous company law board.
Yes.
What would you explain on this?
But there may have been over 10%. I will see. But the Companies Act 56 did not oust the civil court's jurisdiction. That was judicially held. In fact, that's why from 2000.
That's there. LIC's cases, the number of cases are there.
No, I mean that the availability of company law board jurisdiction, or even 397 High Court, because previously 397 was also High Court, just because a litigant having say 20%.
This is another issue, whether 10% barrier, 10% threshold is there or not.
That must be here.
You check this and come on the next day.
I will check and come.
That will be the major argument.
And what is the effect of, if at all 10% more, what will be the effect of it?
Because if it is less than 10%,
then it goes out for sure.
That's why you have to explain.
But now 10% may not be relevant factor, because under Section 244, even below 10%, one can apply for waiver, which was not there earlier. One can apply for this.
You have to stick to one point, whether 56 Act will apply or not.
Yes.
If 56 Act applies, 399 will be applicable, will be relevant for consideration. If you resort to new provision under 2013 Act, then your argument will be demolished.
Well, I am not seeking transfer. Well, I am not seeking transfer. I am resisting this. I'm sorry. I'm not seeking transfer. I'm resisting the transfer. I'm resisting the transfer, but then on the ground.
If your point of argument is that Section 2013 Companies Act is not applicable, then you have to confine within 399 and 397. You have to argue to what extent 399 applies.
There was a bar. And what was the shareholding? That's a point
Because
taken,
if you come to 2013, then this part of your argument will be demolished. What you are arguing right now will be demolished. So you have to, if you continue with this argument, you have to explain we are within the periphery of 1956 Act, and you have to show whether 399 affects you or not.
I will come. Well, Lord, you kindly, this is a point which will Lordship will legitimately taken because this was not argued by them. So I have not covered in my note, or I am not, no, this is not a point taken in their application, but
I
it's
also
a point
seek
of
for
law.
explanation from Mr. Clarification from Mr. Banerjee.
We shall do that.
Because this point, I can certainly notice this point is there. This should be argued. That was not argued.
Certainly argued. Yes, certainly. Well, they have preliminary.
Nah, because we were waiting. Preliminary, we didn't file.
They have not given their note as yet. They are the applicant.
You have to, you are defending the application. Yes. You are defending the suit. So you have to say this point.
Yes. Well,
if this point goes, basically this point is
we have to counter this argument.
Basically, he is attacking the suit. He want to demolish the suit. He want to rejection of suit. If this point is in their favor, against them, they must not argue this point.
That is absolutely right. I've got it.
Because if this point demolishes their case, why they should argue this?
But you can keep it anytime, Lordship, whenever comes to mind.
How long would you take?
Couple of weeks to get ready on it.
Heard in part, adjourned to 4th July.
Great.
Grateful.
Have you filed supplementary affidavit?
Yes, we have filed it, Your Lordship. Item number 14 to 16.
Where is your other side?
Actually, they did not appear on the last several occasions. We've annexed the deed.
Have you mentioned number of the deed?
Yes, it's 4338.
Where is that?
The deed is there, top left-hand corner. I've mentioned it in my supplementary affidavit as well as the deed is there. It's 4338. Dated 13 June 91. Registered at Ghatshila.
This should be earlier. This prior A should be in your application. And even then you have not mentioned, although it is there, you have not mentioned the very deed number.
Yes, deed number is there.
Where have you mentioned?
Deed number mentioned, It is there in the deed itself.
Deed itself not
Yes.
mentioned. Not mentioned in the application.
Deed,
It is not there.
no, deed forms part of the affidavit.
That is separate issue.
Should have been more careful. Should have been more careful. I bow down.
Where is your other side?
They are not appearing. All of a sudden, they've disappeared on the last 3 or 4 occasions.
No, last day they were there.
No, last day, Victor Moses appeared on behalf of the plaintiffs. Victor Moses was there.
Different number 1 appeared.
Yes.
1G,
This-
1H
this
appeared.
fellow, this
Today I will not fix it for order. It is tomorrow or day after tomorrow. Because there is the resolution not to pass adverse order. Supplementary affidavit filed today by the. You are for
one. I'm for 1.
defendant number
Defendant 1G.
1G.
Show karo Yatish. 1GH. 1.
2B1 on behalf of defendant number 2B1 be kept in record. Defendant or plaintiff? Defendant.
Defendant.
Be kept in record. None appears for the plaintiff. Adjourn to 24th June for further hearing. 4th June.
Actually, this is being supported by everyone because of the common cause. It's only this troublemaker, this Sharkar, his wife is coming, and because the husband has sold the property and siphoned the funds.
That day I will fix it for order. Today I cannot pass any order adverse.
Very.
There is no, there is a resolution. কোনটা চেয়ে পাঠাবো? The learned registrar original site is directed to place before this court GA number 61 of 2019. No paper is there for J60. What is 16.1?
Below the item, no. There's one
15.
application for sale of the Bovaja properties that has been published by the receivers.
That is 61. That is item number 15.
They were supposed to file a report today because
What is item number 15? No paper.
Yes. 15 is the one, 15 is the application for sale of the Bovaja property.
That is not placed.
Your order 12 rule 6 proceed and get mine. Kishan Memani should also proceed.
That the receivers want to
Yes, I am passing a direction to place that record.
and the publication has already been made.
I have the papers are to be placed before this court.
Yes.
That's why I am passing direction.
Item number 17,
Lord, in this matter,
17 and 18.
Your Lordship would recall, we had filed a note indicating.
GA13, we are hearing GA13.
We are GA 195, I'm sorry, 964, and
Three applications are there. GA13 of 23.
Yes.
That is in CS 510 of 93.
If your lordship considers.
Your Lordship, I appear in GA 13 of 2023, but Mr. Chaudhury's application was being heard first on the last occasion.
There are two matters. Item number 17. Item
is
number 17 is my lord the CS number 195 of 2010.
Item number 17, CS 510.
18
CS 510 of 1993.
Yes, now CS
Yes, 510 is my suit, Your Lordship. For specific
so
purpose.
far as this is concerned, 510, my lord, GA 13 was taken out by my lord the plaintiff. My lord saying that this should be heard analogously with my lord CS 195, which is the next suit. Now, my lord, so far as that application is concerned, your lordship may consider that application. I say that, my lord, there is no question of the analogous hearing of the two suits. The subject matters are completely different. The parties are not aligned, etc. So, my lord, if my learned friend wants to, my lord, press that application, he may do so.
Now, so far as the other applications are concerned, in CS 195?
Yes, my lord, 195, my lord, my learned friend has taken out an application of judgment upon admission. We are prepared to proceed with the hearing of that also. Now, my
9th
lord,
of 18.
My lord, I am also prepared. My lord, may I, my lord, start with that?
well, the only thing is, well, so far as
Just come to
13 is concerned,
GA 13.
A13, let that be heard first. That is
GA
first in
13.
the list.
My lord, similar subject matter.
No, my lord. If it's let my learned friend argue it.
Let it be heard.
I have already, my lord, argued on GA number 13. I had completed my submissions. I had filed my note. Now, my lord, GA 964 is my Order 12 Rule 6 application. While arguing, my lord, GA 964, I'll have to give your lordship the background, which I propose to do from the earlier note which has been filed by me. And then, my lord, I'll, my lord, argue GA 964. Lord, may I,
Kindly, my lord, conclude hearing of the GA, my lord, 13 first.
Yes, let it be done first.
Yes. My lord, kindly have a look at my lord GA 13.
Lord, please, my lord, have a look at GA
No, so
13.
GA
Have you finished your argument in GA 13?
Yes, my lord, kindly take the note also in GA 13. My lord, there is a note which is, my lord, titled CS 195 of 2010. It says notes of arguments for analogous hearing of the suits. Lord, please ignore.
That should be CS not 195. That should be CS 510 of 93.
Very well. I'll correct it. I'll correct it, my lord. Now, what is important, my lord, is the subject matter. Lord, there are two suits. My lord, please see the first, my lord, page. The first suit is, my lord, CS 510 of 1993. The plaintiff is Kishan Mimani. And the defendants are, my lord, lordship will see, my lord, Kocher. It's, my lord, 1, 2, 3, 4, 5. Second, my lord, suit. Plaintiffs are, my lord, Maheshwaris. Defendants, my lord, are Kocher 1, 2, and 3, and Mimani is 4. So, my lord, the plaintiff in the first suit is the fourth defendant in the second suit. Now, my lord, please see what is the subject matter of the two suits. First, my lord, thing to be noted is this: both, my lord, relate to a partnership firm. Bharat Industries and Commercial Corporation is the firm which was constituted by a deed of partnership dated, on the first page of the note, my lord, C, which was constituted by deed of partnership dated 23rd December 1972. There are two partners, my lord. Mohanlal
You just mentioned where you stated the very ground of analogous hearing.
Yes, my lord, I have indicated. It's a two-page note. May I take your lordship to it, my lord? So, Mohanlal Maheshwari and Mohanlal Kocher were the two partners. Mohanlal Maheshwari, my lord, died on 17 December 1984. Our case is that upon the death of, my lord, one of the two partners, the firm, my lord, stood dissolved. Now, my lord, what has happened is plaintiffs in CS number 195, which is the second suit, they are, my lord, the heirs of Mohanlal Maheshwari. The defendant numbers 1, 2, and 3 in the second suit are the heirs of Mohanlal Kocher. Defendant number 4, my lord, is Mr. Shah's client. He, my lord, claims to be an assignee of the shares of Kocher. So, my lord,
You don't appear from your. No, Orik.
Okay, I'm sorry, my lord. Not Mr. Orik Banerjee, not Mr. Shah. So, my lord, we have the Maheshwaris, we have the Kochers, and, my lord, we have Mimani, who claims to be an assignee of, my lord, Kocher's entitlement in the firm. Now, our case is that after,
May I take a preliminary objection? Kindly see, my lord, the cause title of the application, GA 13.
May I just finish in
No, my lord, my learned friend will finish, but my lord, I'm taking this objection so that he can respond.
So,
my lord, here, if your lordship will see, the plaintiff is Kishan Mimani, plaintiff petitioner. Now, my lord, if your lordship sees, Matlab, the second page, the humble petition on behalf of the plaintiff petitioner. So, matlab, the application for analogous hearing is taken out by Kishan Memani. Now, matlab, who is moving the application? Matlab, Maheshwari. Well, how can that be?
There is an order.
No, matlab, the application is taken by someone. Someone else is moving that application.
I have a right to say in view of a previous.
Matlab, let the person
I'm
who has
sorry,
taken
Milord,
out the application move it.
Milord, I am not moving the application. There is a previous order of court. Your lordship said
Matlab,
that the
whoever is the
I'm
applicant
sorry,
must move the
the
application.
procedure of hearing has to be laid down. It's not nothing to do with an application. Procedure of hearing has to be laid down.
Mr. Banerjee, have you filed this application?
Your lordship, this is yes, my application for analogous hearing on the basis of a division.
I am not interested in his application.
Well, let him move the application. The application has been
Your
filed
lordship,
and
if your lordship wants to
supposed to
hear
move
me
this
out, your lordship will. Yes, if your lordship, may I clear it out, your lordship? On the last occasion, Mr. Chaudhury's application for order to rule 6
Milord,
has been
I am
heard
on
first.
CS number
Yes, place this
195.
application. He has placed this application because he was saying that if his suit is decreed, then my suit becomes infructuous. So that's why this in the interlocutory application in order to rule 6 filed in their suit was heard first. If your lordship
No,
wants
so
to
far
hear
as this
me,
application is concerned,
I have
this is
filed it. I have filed it.
so you have to move this.
That's right.
I will. If your lordship
May I
wants to
humbly
hear me out,
submit?
Just a
kindly-
minute, let me hear
kindly-
Mr. Banerjee.
Your lordship wants to hear me out, kindly keep it any day after tomorrow or next week. I will come and make my
No,
submission.
that is fine. But now, Milord, I had
Lordship wants to hear
started
me out.
making submission. There is a reason. You can't suddenly, Milord, hijack, Milord, my position. Milord, there are two suits. First, Milord, is
Who
CS
are you
5.
right now?
Milord,
Who are you?
I am the plaintiff, Milord, in CS 195.
No, so far as
I have an order 12 rule 6 application,
so far
which
as
is parted
570
before your lordship.
570 is concerned. In 570, who are you?
510. Not a party.
510.
I'm not a party.
You are not a party.
No.
Then why are you making submissions?
I'm not making submissions.
Let
I am
Mr. Banerjee-
making, no, Milord, I am making submissions in CS number 195 of 2010. I have an application under order 12 rule 6, which is Milord parted. When I am making that argument, Milord, your lordship's pleasure was that in view of a previous judgment, Milord, which says the suits must be analogously heard, your lordship wanted to see what would be heard first, what would be heard second, or would it be heard together. Apropos that, Milord, I filed a note. Now, Milord, what Mr. Banerjee files in the other suit, I'm not concerned with. I'm concerned with my suit. So, Milord, apropos your lordship's question, is my note. Otherwise, Milord, kindly take up my order 12 rule 6 and Milord,
I will
please
hear
conclude
this
the-
first. Mr. Banerjee is seeking for time. Let Mr. Banerjee appear tomorrow or day after tomorrow. Would you come day after tomorrow?
Your lordship will kindly keep it on Monday. Your lordship has some
No, Milord,
difficulty day
may I
after
just say this, Milord? I am not a party to Mr. Banerjee's suit. I have my order 12 rule 6.
That is a separate suit.
Yes, it's my suit. That's the only suit where I am a party.
You're Kishore Memani.
Milord, I am Seema Maheshwari and Milord, the other Maheshwaris. Milord, please take up Milord CS number 195 and my order 12 rule 6. Mr. Shah said he has no problem if the matter proceeds. Let me proceed with my matter. I'm not there in his suit.
This matter is heard in part. This 13. So let this be
13,
finished.
Milord, I am not Milord a party to 13. It's
13
not
has never
heard in
been heard,
part.
your lordship. 13 has never been heard. Mr. Chaudhury's application has been heard.
13 has been hard.
13, Milord,
No,
I'm
no,
not
no.
concerned with.
Mr. My learned friend, of course, is not concerned with.
13 has not been heard. 13 has
He
not
should
been
not poke his nose in it, my lord.
Correct,
As he's trying to do.
Absolutely.
My lord,
I am in
13,
my
13 is, my lord, what your lordship was hearing. Your lordship has not heard it at length, but my lord has heard it piecemeal. If your lordship wants to hear 13, we are, my lord, here to assist you. Lord.
Lordship, GA13 is my application. It has not been heard. Mr. Chaudhury's application
All
was
right,
being
come
heard.
on the next.
May I humbly submit, Milord? I am not a party to Mr. Aurik Banerjee's suit. Milord, I can't be asked to wait, Milord, till Mr. Aurik Banerjee makes his sub. My suit is different. Please hear my suit. It's got nothing to do
Both
with this suit.
applications, I will hear both the applications.
Milord,
Let one by one it will be heard. Since 13 has not yet been heard,
and my application has already started, Milord,
then
may I
this will
proceed
be
with
heard.
my
Anyway,
application?
Mr. Banerjee is not here. Fixing it day after tomorrow.
Yeah, after
Day after tomorrow, Monday. You said Monday.
Monday, yes.
Monday.
Monday হবে দেখো তো।
Or the day after tomorrow also, no problem. Your lordship.
Day after tomorrow.
Yes, very good.
Milord, I will, Milord, come and Milord, argue my application under order 12.
As
rule
if it
6.
is hard in part, then it must become finished.
I'm not concerned with GA13. If your lordship needs my assistance for which should be heard first or which should
No,
not be
if
heard.
it is part heard, this GA, which you say part heard,
My lord, my application
that is
is part
GA5.
heard.
5.
That is GA5. GA5. So that has to be heard. And my lord, both my
Hearing
lord,
of that
Mr.
must be finished.
Yes, both Mr. Shah and Mr. Arik Banerjee are both respondents there. We'll conclude our submissions there. It's an independent suit. I'll proceed. Now, insofar as GA13 is concerned, which is Mr. Arik Banerjee's application, it's in a separate suit. I'm not a defendant. I'm not concerned. My application may be completed. And any milord, any order which is passed in his suit, which says that his suit should be heard with my suit, I should be heard once before that order is passed. I'll come day after tomorrow and move my application for judgment upon admission.
Mr. Chaudhary, I was praying for Monday if you don't have any problem.
I have
If your
no
lordship
problem
diary
with
permit.
whichever day
Monday
you
holiday.
want.
You're withdrawing your note, no? Which you
Then Monday.
Monday
Monday means 24th.
Milord, on that date, milord, may I
Your
24th.
application will be heard since it is part heard.
grateful, milord. So please, milord, direct my lord's
Fixed
officers
on
to
prayer of
list
the learned counsel for
195
the
first.
No,
That will be
let
the
it
matter
appear in
is
the same
adjourned-
sequence in which it is appearing
adjourned
today.
to 24th June for hearing GA number 5 of 2018 in CS 195 of 2010.
Grateful.
GA 13 in 2020, 13 of 2023 in CS 510 of 93 shall be taken thereafter.
Great.
Very well.
Grateful.
Change for the mistake now.
I give it.
Raghu? Item number 19.
None appears. 4 নম্বরটা রেখে দাও তো পাস ওভার 4 নম্বরটা none appears.
Passover matter.
দাঁড়াও অর্ডারটা শেষ করতে দাও.
হ্যাঁ, my lord, হ্যাঁ।
None appears. Adjourn to 25th July. 4.
Item number 4, Passover matter.
Item number 4, I appear for the plaintiffs. The matter was it's a 2015 suit, lordship. Initially there were 12 defendants. The defendants did not appear and the suit was marked as undefended suit. However, lordship, we had taken out an application for appointment of a receiver commissioner as to ascertain who is the occupant of the property. Upon ascertainment, lordship, 3 new defendants have come in. They have been added as defendants and they have started appearing and they have filed their written statement as well. So, lordship, on an earlier occasion, we had taken out an application for injunction as to restrain them, not to create any third-party interest or to pass on the property.
Status quo order was passed.
Yes, lordship. Status quo order is there. The written statement have been filed. Now we can proceed with the suit, with the inspection and
But that
discovery.
GA
and
5
filling
of
of the suit.
23 is still pending.
No, lordship. It's been disposed of by your lordship's order dated 15th May, lordship.
Okay. None appears for the defendants. I will not pass adverse order in absence of anyone. Let it come after a date when discoveries, inspections, all these things shall be done.
Very well, lordship.
Adjourn to 21st August. Discoveries and inspection of documents as well as filing judge's brief of documents shall be complete in the meantime by the parties.
Lordship, the issue though also has to be framed.
Let this be done, then issues are to be framed.
নামটা দেবেন। Raghu? For orders, item number 20.
Sir, I am for the plaintiff, Lord. This is an application for mean profit. Now, your lordship, remember, my lord, your lordship appoint, my lord, special referee, but special referee did not appear, my lord, in spite of service. My lord, last occasion, my lord, your lordship fixed, my lord, allowed, my lord, if the parties agreed, your lordship fix the quantum of amount and complete this. My lord, this is a Marshall House property, my lord, in NS Road.
Have you agreed anything?
My lord, I am for the judgment dated number 2. The question is that in the decree itself, the Honorable Court has directed appointment of a special referee. A special referee took evidence, everything, hearing, and thereafter hearing, he given his report.
That
And the-
report has been set aside by
That,
your lordship.
that is what I am submitting, your lordship. The question is that report has been set aside, but the question is now that thereafter, your lordship, on the earlier occasion when the order was passed, your lordship directed appointment of another special referee to work it, because your lordship, the thing is that when the question is that in that case, before the another special referee, there has to be taken evidence of and all those things appraised, because that proceedings have gone. Now what are there then?
Special referee did not appear.
Special referee was appointed.
Yes.
Special referee is to calculate mean profit.
Not only conclude, because he is to inquire about, and then only then, otherwise.
Have you sent any notice to him?
Registrar also sent a notice, my lord, in spite of your, in terms of your lordship's order. But he did not appear.
He did not appear. So, your lordship, that is why you.
Where is the report of the register?
First April 24, my lord, your lordship passed an order, my lord. The learned registrar on your side to communicate this order to the special referee.
Or you suggest we settle the matter, we can.
That's
There is no possibility. Why I am saying this, your lordship? We have said that we have got only 65 square feet area in our occupation. We have got no income from the property. That
area is about
kindly let me submit. The question is that out of the entire area, your lordship, 850 sub-leases are there who are in occupation, who are not party to the means a profit or the suit. The question is that, your lordship, when I am to pay, where from I shall pay? That is why that is why the evidence has to be taken, because the thing is, they have claimed 8 crore,
So that means there cannot be any settlement.
No.
All right, let report is check.
Lord, my learned friend is dependent number 2. Well, my learned
That
friend appointed, Lord, sub.
Please. আমি লাস্ট অর্ডারটা কবে করলাম? All right, I will check it. Come on the next week. The learned special referee is not present in the court. He may be reminded to appear before this court on the next date. Let the matter appear in the list on 26 June.
Item number 21.
No, I am appearing on behalf of the defendant, my lord. This matter was supposed to appear under the witness action, my lord. Last order.
Who is your other side?
My lord, Meghnad Datta was appearing, my lord. Tara property, that matter, my lord.
Yes. So let me fix after a couple of days. Adjourn to 23rd July.
Good.
Mr. Datta has a bereavement in his family.
I did not know
Mr.
that.
Datta,
My lord. I did not know that.
his brother has expired recently. His brother has expired.
নামটা দেবেন
22.
My lord, I was
Item number
appearing,
22.
I was appearing for the caveator, my lord. Our arguments have
Who is
concluded.
your other
my lord.
side?
My lord, kindly give me 1 minute. Mr. Chaudhary is just outside the court.
Mr.
He is
Chaudhary
coming.
was to conclude his reply.
Lord, may I do this tomorrow if your lordship permits me?
That was on Monday.
Yes.
On Monday?
Monday, my lord.
Adjourn to 24th.
Madam, I was led by Mr. Chatterjee appearing virtually.
Give a slip.
Oblige, my lord.
But I have to fix for two big orders.
Very interesting. I completed the note yesterday.
No, would you be able to finish that? That would not be finished on the next date, Monday. You can finish, but Mr. Shah may not finish.
No, that will go on. But this one, I am in reply to Mr. Bachawat. This I will finish on. I'll take 15.
Item number 23.
23, my lord, I am for the plaintiff.
I'm for the defendant, my lord.
The last occasion, my lord, they have filed the written statement that was defective. Thereafter, your lordship directed them to cure the defect. And they have cured the defect and they have supplied a copy of the corrected cost titles and defect, my lord. So now I shall file the additional written statement, my lordship. Kindly give me 2 weeks time, my lord.
There is a counterclaim.
Yes, there is a counterclaim. I shall file.
So you have not filed additional written.
I shall file now.
The learned counsel for the plaintiff seeks for an accommodation and extension of time to file additional written statement against the counterclaim. Time is allowed. Extension is allowed. Additional written statement shall be filed on or before 23rd July.
23rd July. Well, I am led by Mr. Mitra Maladi.
Of item number 31, it appears that his suit is pending, but well, so far the defendant number 4 is concerned, we have filed the 2 applications which is due to appear on Friday, my lord. So, my lord, I will be requesting your lordship, this is a notice copy. I request your lordship to take up the matter of the interlocutory applications first, and thereafter item number 31 be taken up.
31, my lord, is my matter, my lord. I am for the different number 3, 2 and 3.
And I am for the different number 4.
I have not been given any notice.
Yes, filed certain application.
Yes.
I have not been served, neither copy of.
I will serve. I will serve
given.
in course of today. I will serve in course of today.
That is right, but I should have been given a notice.
I am giving.
After the matter.
I am different number 4, Milord.
31.
Applications filed on behalf of defendant number 4 has not come up today for hearing.
Is due to appear on 21st.
Which were due to appear on 21st June 2024. Let this matter, let the suit along with the applications appear in a list.
Only one.
Please.
One. I must be fair to the as the officer of the court. This matter was taken up by Justice Krishna Rao and was directed to appear on 11th June. No date was fixed on 21st.
Let it appear. Then, if I fix a date, what is your problem? Then, interrupting the dictation.
That is the reason I was trying to tell him.
Let the suit along with the applications on not as a witness action. এটা দেবে যেন না আসে. Under heading for hearing within court on 27 June. 27 June.
27 June. I'm grateful, my lord. Then the matter will not appear on 21st.
21st is fixed.
It's fixed for the applications. So my lord will direct that the matter will not
21st, then 21st.
21st. I'm grateful. Extremely grateful. I'm immediately serving the copies.
I'm grateful, my lord.
Item number 24 and 25.
I appear for the plaintiff, Milord. But the defendants were, Milord, advancing their arguments.
Mr. Dotto was
Yes,
arguing.
Milord. Milord, none of them are here today. There is a resolution, so I cannot also proceed, Milord, ask for
Right.
anything. But you will kindly fix a short date, Milord, next week, if it is possible, Milord.
Sorry, the non comes in. Only I am adjourning it.
Milord, because Milord, 2005, Milord, PLA is of 2005. It has been heard twice before, Milord. That is only
This
reason.
part heard, otherwise I would have
I know,
released this
I'm,
matter.
absolutely, Milord. Milord, as short as possible, Milord, subject to your lordship's consent.
27, adjourn to 21st June.
Grateful.
This Friday.
Great.
Item number 26 and 27.
No, appearing for the petitioner, my lord, my senior is
For the
not in
defendant, my
sight.
lord.
My lord, kindly give a pass over for 5-10 minutes here. My senior is coming.
28.
Item number 28.
Thank you.
Who is for the defendant?
Undependent suit. And my lord,
Your witness is here?
my lord,
Your witness, have you brought your witness?
today actually what has happened, my witness, only one witness, the plaintiff, who already deposed. And my lord, witness is that evidence is, my lord, concluded. My lord, thereafter, my lord, his lordship, Honorable Justice Rao, passed an order. If your lordships kindly have a look to the order passed on 17 January. My lord, there is some direction to produce the records by the, my lord, learned executive magistrate. And also, my lord, it was directed to serve the special officer. Now, the present moment, the special officer who was appointed, my lord, he is not coming, and his residential address, my lord, it was served, the notice. But, my lord, he is not there. Even he sits in court room number 2 of the Bar Association. There, my lord, he is not also coming. The difficulty is, my lord, since there was a direction to, my lord, inquiry into the matter pursuant to the order passed by Honorable Justice I.P. Mukherjee, the first order on 12th October 2012. My lord, the special officer, Mr. Prathaprotim Chatterjee, was appointed he took the symbolic possession of the suit property. And my lord, he was directed to file a report also, but he is not coming. He has also not filed any report. And my lord, in this situation, my lord, if your lordships kindly appoint another special officer to inspect the suit premises and to file a report, and my lord, since it is an undependent suit, my lord, the dependent is not residing over there, and my lord, the other address which was given, we came to learn that she was residing, that there also is sub, my lord, that was come by.
Where is the report of registered original site?
Mentioning by mentioning by the report has been
This is the affidavit service we served upon the learned register original side.
আমাকে রিপোর্ট দাও, রেজিস্টার অরিজিনাল সাইট রিপোর্ট কোথায়? No report is placed by the learned register original site showing compliance with the order dated 29th April 2024. The learned full stop. The learned register original site shall cause to be submitted before this court a report in terms of the aforesaid order. Let the matter appear in the list on 28 June.
But may we permit to file the judge's brief of document?
Let the affidavit, have you filed the affidavit? Affidavit of service be kept in record.
Affidavit of service and all of the
Judge's brief of document filed by the learned counsel for the plaintiff be kept in record.
I can see.
Item number 29.
The defendant's witness was being cross-examined, my lord. I'm led by Mr. Bose, my lord. I'm praying for a short passover, my lord.
Only 1 or 2 matters are left.
My lord, only short passover, my lord. 1 or 2 minutes, my lord.
Otherwise, I will adjourn it.
Yes, sir.
If you are not able to come.
Also, they did not turn up. My witness.
We are here, my lord. I'm led by Mr. Bose, my lord. He's on his way, my lord.
30.
Just two.
Item number 30.
Order sheet देखिए. You are here.
I am other Passover matter, item 26, I am ready.
None appears. Who is in 30? Adjourn to 4 July. You were in 26.
26 and 27 minute arguments are to begin. Analogous suit. Analogous suit.
Yes, who is you are for?
But I am for the plaintiff in the first matter, which is my lord.
Who adduced evidence last? Who adduced evidence last?
My lord, the plaintiff's witness in item number 27, my lord, was being adduced, was adducing his evidence, my lord, by way of a commissioner, my lord.
Who will begin argument? Plaintiff.
The defendants, my lord, the plaintiff, my lord, in item number 26, my lord, have
Who will
begun
begin
their
argument?
arguments, my lord. On the last occasion, your lordship, the plaintiffs in item number 26, my lord.
We had started, but technically what is falling from your lordship, my lord, as per in this suit, the defendant was last examined.
She came.
Yes, yes. Ms. Chakraborty is my junior.
That is mentioned. Nirmal Kanoria was examined.
Yes, my lord.
On 26th April.
Yes. Nirmal Kanodia is the defendant in CS 124 and is the plaintiff in 264.
So no other witness is to be examined. That's why it was fixed for argument. So Ms. Chakraborty, that means you are supposed to start argument.
And I am for the plaintiff, I can start. I don't mind. I can start.
You are plaintiff as well as you are
I am plaintiff in CS 124, which is Basudev Agarwal. Well, in my suit, Nirmal Kanodia was the defendant. Defendant number 1.
In that suit, you are plaintiff.
In CS 124, I am the plaintiff.
Nirmal Kanodia is your other side.
Nirmal Kanodia is my other side.
So they have to start.
Technically, yes, man. Technically, yes.
You can hear always start also. Because
But
already,
both suits are being heard analogously, my lord. It
so
doesn't
it will
really
not
matter.
make no difference.
The
Yes.
Lordship will kindly take, my lord, the records of at least the plaint and the written
You give me the gist of the case
Yes, yes. 124.
without going into any detail so that I can have an idea.
Yes. Well, at CS 124 is by the Agarwalas against the Kanodias, and it's a money suit. Both are money suits. The cause of action is arising out of a MOU dated 20th September 2010, by which a company which was controlled by the Agarwalas was agreed to be sold to the Kanodias or the entity controlled by the Kanodias. They were to take over that company. Shares.
Agarwal agrees to sell a company to the Kanodias.
The reason being that company was having debts from the bank. There were bank proceedings. They were having debts from the bank. They were unable to run the company efficiently. But the company had assets. And the bank dues was much less than the assets. So, my lord, this agreement or the MOU was entered into. The total consideration for selling that company was around 28 crores. And my lord, this 28 crores is this consideration that was agreed. And these are agreed consideration. Bank dues would have been much less to the tune of... Bank dues was around 21 crores. But 28 crores was the agreed consideration. It was agreed first they would pay off the bank and my lord, they would take over the shares of the company. This was, my lord, the modality of the arrangement, being the subject matter of the MOU of 20th September 2010. And my lord, there was a cut-off period which was mentioned of 30th November 2010, within which, my lord, this payment would have to be made. I shall show your lordship the terms.
MOU dated 20th September 2010.
MOU dated 20th September 2010. My lord is looking at the plaint.
Yes.
My lord will kindly, my lord, MOU is actually, my lord, Exhibit A. That lordship will find, my lord, if lordship...
I will come it later on.
Okay. So, my lord, if lordship is looking at the plaint, lordship will find that pleading. Kindly straight away come to, my lord, before that, my lord, kindly come to paragraph 5. In fact, my lord, I first show para 2, my lord, the name of the company, lordship will get it.
Bhumi.
Plaintiff number 1 and 2 floated a company named Bhumi Minerals. So, Bhumi Minerals is the company.
Defendant number 4.
Yes. Now, my lord, kindly straight away come to para 4. As the business of the sponge iron unit of the company demanded huge capital investment and working capital, the promoters of the company had availed huge financial investment from banks and financial institutions. Indian Overseas Bank being one of the prime lenders, the repayment of loan and advances of the Indian Overseas Bank of the said company were secured by personal guarantee of the plaintiff and pledging collateral and corporate securities. Then para 5, my lord, we say that we were unable to pay or timely service the accounts with Indian Overseas Bank, and it was covered under the bank was contemplating steps against the company. My lord, it is in this background this MOU was entered into. That lordship will find that at para 6. In such circumstances, in the month of July 2010, the defendants herein above approached the plaintiff and evinced their interest to purchase the said company and or take over the management at a lump sum consideration. Then, my lord, negotiation, discussion comes, lordship straight away comes to para 8. In furtherance of modalities of transfer, it was agreed between the plaintiff and the defendant that a memorandum of understanding...
Who is your other side? Someone is there?
Yes, yes. My learned friend is there. will be executed between the parties, which shall guide the further course of action. Thereafter, by consent of both the parties and their approval, and after analysis of each terms of the MOU, a joint memorandum of understanding dated 20th September 2010 was executed between the parties. Time was the essence of the contract. Then, my lord, MOU is annexed to the plaint. MOU envisaged. Kindly note, my lord, total consideration was 28 crores, which was to be paid by the defendants to the plaintiff towards total consideration for share transfer as well as sanction of loan advanced by Indian Overseas Bank. Upon receipt of payment from the defendant, the plaintiff in turn would have apportioned the same towards satisfaction of loan advanced by the Indian Overseas Bank, and simultaneously would also have carried out necessary share transfer in the name of the defendant. So, my lord, why I say this? The 28 crores, the consideration was much more than the bank liability. So the arrangement was, the moment you pay this amount to me, bank liability is met off, and after that, my lord, the shares are transferred. Everything happening simultaneously. That was the, I'll come to the, my lord, nitty-gritties, the detailed terms of the MOU, which is Exhibit A over here. But to cut a long story short, just to give your lordship the background, that ultimately, my lord, they paid a token sum of 1 crore. And
to
then,
you?
Yes. And then, my lord, they cancelled it by SMS that we are cancelling the agreement in September. 24th September, my lord, they cancel it. And my
No,
lord,
so if the 28 crore was the consideration money, 28.01 crore.
Yes.
Now, out of this, payment will be made to bank.
The 28 was the consideration for transfer of shares, but this was in the background of a bank liability. So, my lord, from the 28 crores, I would have paid 20 crores to the bank, and perhaps I would have got 8 crores.
Something like that.
But the main idea was, my lord, to meet the bank liabilities. Otherwise, my lord,
who will pay the bank liabilities? You or they?
The money was, otherwise, my lord, they would not get the securities back and everything back. My lord, modalities are worked out. My lord, this is agreed on 20th of September. On 24th of September, my lord, they by SMS say, I am backing out of the contract.
Only paying 1 crore.
1 crore. And then, my lord, in the meantime, what happens? Because, my lord, we had surfacey proceedings was, my lord, being threatened, my lord, 13-2 notice was issued. Surfacey notice was issued. And, my lord, in the interregnum, after they back out, and because, my lord, in the surfacey, my lord, lordship knows, my lord, it's a distress sell. My lord, we would not get the price the company would have actually commanded. So, my lord, ultimately, when they terminate it, my lord, we put them on notice that, look, your termination is not correct. And when they back out, my lord, we are forced to sell the company to a third party at a lower consideration of 21 crores or 20 crores and not, exactly to meet the bank liabilities. We are forced to sell it.
So your case is that you lost 7 or 8 crores.
Yes, 6 crores and odd is the differential amount. So agreed consideration as per MOU, and, my lord, whatever I have sold,
they are supposed to give you 28.
28. I have
they
sold
did not.
at 22 and 22 and a half, and the balance, my lord, I have asked for in the suit. This is, my lord, the sum and substance of my suit, which is CS 124 of 2011. And their suit, which is filed, my lord, after 1 year, according to us, as a counterblast, my lord, they are, my lord, claiming this 1 crore which they have paid, they are claiming that money back. So therefore, my lord, the issues are identical. Issues are similar. I can't say identical. So they are claiming the 1 crore which they have paid back, which we are saying.
At the base is this memorandum of understanding.
And the base is this memorandum of understanding. And, my lord, the evidence is also, my lord, it's very limited scope. All that lordship will have to consider, because, my lord, in their written statement, they have tried to make out a case that as if they were unaware of the bank liabilities. But, my lord, the documents will show that the entire memorandum was executed in the background of bank liabilities. Otherwise, there was no occasion for me to sell the company. Well, in this background, lordship will just have a look at the MOU, so lordship will get the terms. But kindly take, my lord, Exhibit A, or lordship.
No, it is annexed to the plaint for the time being.
Yes. That in the plaint it is at plaint কোথায় আছে ভাই? The plaint it is the first annexure, I believe, which should be page 19. 19. That if I may refer to the internal pages of the MOU, because when I am looking from the exhibit, it will be easier for me to.
Yes.
So, my lord, the first page, Lordship will find, my lord, party of the first part, vendors are the Agarwalas, Vasudev Agarwala and Suresh Agarwala. And, my lord, the second part are the Kanodias, my lord, rather, my lord, Nirmal Kanodia, Mahendra Padia and Rajendra Kumar Singhania. They are the purchasers. Now, my lord, kindly straight away come to internal page 2 of the agreement, the first recital. Whereas the vendors are the main shareholders and have controlling interest in the company known as.
No, it is mentioned in paragraph 15 that collateral securities and personal guarantees of the vendors to be released from Indian Overseas Bank.
Yes. Lordship has got the crux. So, well, there is no doubt that the agreement was in the backdrop of, my lord, bank liabilities. And, my lord, the consideration Lordship has noted at, my lord, clause 2, which is internal page 3 of the agreement. Purchaser hereby agree to pay vendors 28.01 crores as gross consideration for the transfer of ownership.
Bank loan from Indian Overseas Banks. This you want to say?
Yes. And towards the bank loan from Indian Overseas Bank. So, it is in the background of a bank liability which would be met from the consideration. And bank liability, it's also an admitted position. Bank liability was much less than 28 crores. So, my lord, I am getting divested of the company, but I am meeting the bank liability and I am making a, I won't say profit, but I am making money of, my lord, 7 crores and odd, or 8 crores. And, my lord, in that I am selling my entire shareholding. I am selling my entire shareholding. Now, in clause 6, Lordship will find they were to pay 50 lakh on execution of the present and balance within 30th November. But, my lord, not only 50 lakh at that point of time, my lord, 1 crore was paid, 50 lakh plus 50 lakh more, and we were to transfer 51. Kindly see clause 6, this is very important. Why I say so? Because, my lord, we were to transfer our entire controlling interest, 51%. Now, my lord, there is another aspect to it. Not only they deny that I was not aware of the bank liability being the reason for the cancellation, they also try to set up a case. My lord, a document is being relied upon, which is an alleged modification of the memorandum, where it contains signature of only my client, which is saying that transfer, it will be 49-51. That is, we will retain 51 and they will have 49. They say that we did not agree to the modification. Therefore, we are cancelling the agreement. To that, my lord, our simple answer is that if you don't agree to the modification, this agreement remains. And we had asked you to take it in terms of this. We are, my lord, disputing.
So your point is that modification amounts to renovation of contract?
Modification, admittedly, and we are both ad idem that the modification never took place. My lord, firstly, there is a dispute with regard to that agreement also. We are disputing it. And Lordship will not find in any correspondence or contemporaneous, my lord, SMS.
Even if it is so, this is agreed memorandum of understanding. Subsequently, a novation was offered. Novation was not met because that offer was not rejected or
admitted position. They have not even signed it. Assuming
so that cannot be worked upon according to you.
Yes, and my lord, nobody relies upon that. We are also not relying upon it, but they are trying to rely upon it to cancel the parent agreement. My lord, it's like this. I don't agree with the terms of the novation agreement, so I am cancelling the parent agreement. In law, that is not permissible at all. Assuming, my lord, it can be said to be a genuine document. I'll come to that later. So, my lord, this is the term. Lordship has seen, my lord, and my lord, this agreement itself clearly, my lord, there can be no manner of doubt that it is in the background of liability towards Indian Overseas Bank. which has been spelled out not in one but more than one places. Lordship has only noted two of the such paragraphs that Indian Overseas Bank liability was to be met. Now, 1 crore is paid. Balance amount was to be paid by 30th of November. That there was a cut-off date, 30th of November. I shall just show your Lordship that portion.
Para 6.
Para 6. Page 3, para 6, Lordship has already seen. Now, my lord, they don't go into November only, my lord, they cancel. First is, my lord, it is by SMS. Lordship will find that, my lord, at page 12 of the judge's brief. Exhibit B.
Next day, you argue in terms of these judge's brief or evidence. Today, on the pleadings.
Yes, I'll just show your Lordship the broad outline, and next day, my lord, I'll give the
page 12.
Yes.
Exhibit 1.
Page 12, my lord. Exhibit B, it should be.
This is Exhibit 1 written here.
DD2.
Yes, DD2.
Judge's brief of plaintiff, my lord. There are two separate judge's briefs. Kindly take the other one. Because, my lord, what has happened since both the suits were being heard analogously, my lord, that there are two sets of judges. The plaintiff's judge's brief will have the backsheet of Meheria and Company.
Exhibit B.
Yes. This is, my lord, this was recorded, my lord, this is typed out. But, my lord, there is no dispute that the actual SMS was received. They are not disputing it that the SMS was sent. This SMS was dated, my lord, 24th September 2010. The contents are typewritten. I declare my status as withdrawn and cancelled for the MOU signed on 20th September 2010. Kindly arrange to refund my deposit latest by 30th September 2010. And in hand, Lordship will find it has been written, received from Singhania on 24th September 2010, and the mobile numbers have been mentioned. Singhania is
admitted.
Defendant, and this document is admitted, marked as Exhibit B without any objection. There is no dispute. So, my lord, this is the first, my lord, if I may say, the communication of a termination, that I am opting out, I am withdrawing myself from this. And then, my lord, we get in November, my lord, bank issues us a letter, because, my lord, Lordship will note that everything was to be completed in November itself. 6 November 2010, my lord, banks issue us a surfacey letter. That is, my lord, at page 13. And bank demands, Lordship will find 18 crores and odd. And Lordship will find that account is classified as NPA on that date. So, my lord, in the event the payments would have been forthcoming, we would have, the surfacey proceedings wouldn't have happened on, even if it had happened, my lord, kindly see, it is only 18 crore, 81 lakhs and odd.
So that is your point.
And, my lord, when this bank, in the backdrop of a bank surfacey notice, my lord, I had to ultimately, my lord, I sold off my company to another third party at 22 crores.
Much less price.
Much less price. And this 6 crores is the difference which I am claiming from him, because he did not honor his commitment.
All right. Hard in part. Come on the next day. When will you be able to come?
Any day convenient to your Lordship, my lord.
At the date, bolo. বৃহস্পতি শুক্র হ্যাঁ 27 হচ্ছে শুক্রবার 27 is okay. Hard in part adjourned to 27 June.
Passover matter, item number 29.
Witness action.
Yes, but the
Witness is
here.
present.
Yes, I'm told he's present.
Who is your other side?
Well, I'm appearing on behalf of the defendant. What's your appearance?
Last question. Ravinder.
This is the first time witness is examined?
No, my lord. No, my lord. He is in the midst of cross-examination.
He is PW1.
He is, my lord, DW effectively 2, because one witness has been expunged. His deposition, because he died. After, in course
Without
of
being
cross-examination, he passed away during COVID. So, my lord, his witness, the first witness's deposition was expunged. And thereafter, my lord, this is...
Ideally, it should remain to the extent cross-examined.
Well, it was not completed. 1 or 2 days. No, I believe he was not even cross-examined. In fact, after chief, in course of being examined as a chief witness, he had passed away. So his witness action was this.
So basically, he is DW1.
DW1.
You are plaintiff.
I'm plaintiff.
You are cross-examining DW1.
My lord.
Last question.
ছিল বার করে ফেলো লিমিটেশন 20
SEK
ঠিক আছে চলো नाम Mr. Saxeria.
Yes.
In answer to question 25, you have alleged that Mr. Baheti had approached the trust and after 15th March, in course of discussions, Mr. Baheti wanted to refund the money and that the trust wanted to forfeit the same. My question is not over. Would I be correct in saying that there are no documents on record of this honorable court from which this allegation of yours would stand substantiated?
It was a verbal request, sir.
In answer to question 26, you had once again alleged that it was the stand of the trust to forfeit the money.
What was the question 26, sir?
I will show you. Kindly show him question 26 and 27 answer. Have you seen the question and answer? Would I be correct in saying that the trust had never issued any notice to the plaintiff in exercise of their right in terms of the agreement to forfeit the money paid in terms thereof?
Sir, in agreement itself, through which Mr. Baheti paid the money, it was mentioned that time is the essence of the contract. So no notice was issued and the money was forfeited.
Would I be correct in saying that
in terms of the agreement, my lord, kindly give me a moment. What was the question? No, কেটে দিন। Shown clause 4.2 of the memorandum of understanding being exhibit Q. এটা একটু দেখাবে? দিন দিন। Clause 4.2. Clause 4.2.
Seen, sir.
4.2, right. Would it be correct to say that in terms of this agreement, the plaintiff as the purchaser was required to pay the balance consideration at the time of execution and registration of the conveyance?
Yes, sir. Within 28th February 2005.
Would I be correct in saying that the defendant trust, the trustees of the defendant trust voluntarily extended the time extended the time, received payment from the plaintiff in terms of the agreement on 2nd March 2005. Question একবার repeat করে দেবে?
The trustees, no, 1 second, don't write the trustees. The secretary extended the date to 15th of March on request of Mr. Baheti, as he was unable to make full payment within 28th Feb.
Mr. Sakseria, my question to you was whether the defendant trustees accepted and received payment from the plaintiff on 2nd March 2005 in terms of the agreement.
The trust received and accepted the payment in first week of March on request of Mr. Baheti to extend the payment terms till 15th of March.
In answer to question 24, kindly show him question 24. তোমার কথা শুনে এরকম কোথাও কিছু সঙ্গে সঙ্গে দিই পরে আসতেছে তুমি এলেই কিরম সিনারিওটাই চেঞ্জ কাঁপতে আরম্ভ করে দিল সব কোয়েশ্চেনটা একটু বলবেন in answer to question 24 you have alleged that দিয়ে একটু open quotes we have forfeited the amount on 15th March stop close quote is there any document on record disclosed by the defendant before this honorable court with respect to this purported forfeiture alleged to have been made by the defendant trust on March 15, 2005?
The forfeiture.
Please answer the question and then you say whatever you have to say.
There is no document because the forfeiture as per the agreement should have been done on 28th February for non-payment. But because as per request of Mr. Beheti, the timeline was extended to 15th of March. The forfeiture automatically happened on 15th of March due to non-payment, due to not making full payment.
Has the defendant disclosed any document before this honorable court with respect to this alleged extension of time till 15th March 2005?
No, as it was a verbal request and verbal extension.
Mr. Saxeri, I put it to you. তুমি বলে দিলে কোয়েশ্চেনটা শেষ করলাম তুমি আগেই বলে দিলে উত্তরটা বলে দিলে মানে Mr. Saxera তাহলে এই কোয়েশ্চেনটা কেটে দিই মানে যেটা শুরু করছিলাম ওইটা কেটে দিই আগেরটা কেটে দিই জিজ্ঞেস করছিলাম Mr. Saxeria, I put it to you that there never had been any discussion or any agreement, oral or otherwise, between the parties regarding extension of time in terms of this agreement. Regarding extension of time.
একটু আবার স্যার কোয়েশ্চেন বলবেন
মিস্টার সাকসেরি একটু বলে দিন না পড়ে দিন আমি শুনতে পাচ্ছি একটু আপনি জোরে বলবেন আমি
Mr. Saxeria, I put it to you that there never has been any discussion or any agreement, oral or otherwise, between the parties regarding extension of time.
as alleged by you
As per the agreement in writing,
as alleged by you as alleged by you as alleged by you in course of your deposition.
as per the agreement in writing, we could have forfeited the money on 28th February 2005 only. By only as per the request to extend it by 15 days. We accepted the 5 lakhs check given to us on 2nd of 3rd of March. If there was no oral request or agreement, why we would have accepted the part check? Part payment check of 5 lakhs.
Mr. Saxeria, I put it to you that your evidence is contrary to the terms of the agreement and the documents disclosed before this honorable court and is otherwise incorrect and false.
Sir, this is for you to. This is
Say
your
yes or
assumption.
no. Say
No.
yes or no.
No. I disagree.
If you do not agree, say I do not agree.
Okay.
Present at the he was not associated with the
Mr. Saxeria, based on your previous evidence, would it be correct to say that you were not present or otherwise not associated with the trustees as on 15th March 2005?
Yes, sir. Correct.
Mr. Saxeria, না ওইটা না shown Exhibit R, a document dated February 26, 2005. Plaintiff's document number 4, Exhibit R. Yes. Exhibit R বললেই হবে। Would it be correct to say that the defendant trust, তুমি বসো না, তুমি উঠে বললে কেন? চলে যাও, তোমার দেখলে আমার ভয় লাগে।
কেন ভয় লাগবে কেন?
Your lordship is unaware. Mr. Aniruddha Mitra is where, how he will play, which card is up his sleeve.
Mics are so powerful. My God. Mics are so powerful. Let's leave and come back.
Question একটু বলবেন?
Would it be correct to say that the defendant trust,
Despite receipt of this notice issued by the plaintiff's learned advocate, failed to execute and register the deed of conveyance, comma, the draft copy of which was forwarded by the aforesaid letter? Questionটা একটু বলবে?
document dated February 26, 2005. Would it be correct to say that the defendant trust, despite receipt of this notice issued by the plaintiff's learned advocate, failed to execute, failed to execute and register
to approve, আগে approve কথা বলেন।
execute and register, approve, execute and register the deed of conveyance, comma, the draft copy of which was forwarded by the aforesaid letter.
By the aforesaid না করে by the said letter.
Question কি আছে? Question কি আছে? আগে question কি ছিল? Would it be would it be correct to say
that the defendant trust, despite receipt of this notice issued by the plaintiffs, failed to approve, execute and register the deed of conveyance was forwarded by the said letter?
I do not know whether this letter was received and when it was received. I will have to check and then I can only give a reply to it.
Mr. Sexaria, I put it to you that by the aforesaid letter and also prior and thereafter, repeated requests were made by the plaintiff to the trustees of the trust to approve the draft deed of conveyance, execute and register the same, and receive the balance consideration in terms of clause 4.3 of the agreement between the parties dated the date of the 28 January 2005.
তো পড়ুন না কি question কি ছিল?
Mr. Saxeria, I put it to you that by the aforesaid letter and also prior and thereafter, repeated requests were made by the plaintiff, the trustees of the trust, to approve the draft of conveyance, the same, and receive the balance consideration in terms of clause agreement between the parties dated January 2005.
As I have replied to your earlier question, I do not know when the letter was received and whether it was received. So I do not know whether any trustees refuse to approve any draft
deed of conveyance.
Draft deed of conveyance
Would you agree with me that on 5th December 2008, the trustees, the then trustees of the trust, expressed their intention not to execute the conveyance or honored their commitments in terms of the agreement dated 28 January 2005.
You are saying 5th December 2008.
8.
The amount stood forfeited on 15th March 2005. So anything of 2008 does not arise.
Are you aware who has signed the written statement on behalf of the defendant trust?
I have signed.
Would it be correct in saying that the statements made by the plaintiff regarding the refusal by the defendant trust to honor the agreement on 5th December 2008 has not been specifically denied in the written statement?
Statement
কি বললাম একটু সেন্টেন্সটা বল এই প্যারাগ্রাফটা বলবেন ফ্রেকশনটা
Correct in saying that the statements made by the plaintiff regarding the refusal by the defendant trust to honor the agreement on 5th December 2008 has not been specifically denied in the
5th December কি ছিল না কি statement ছিল? What was their statement regarding 5th December?
No, what do you want to know?
আপনি কি statement দিয়েছেন 5th December 2008 এ?
So are you in a position to answer the question?
If I see the question only, then I can know, na?
No, this is not a question. My question, he'll read it out to you. So you have to understand the question. You are the defendant's witness. That's why I asked you, who has signed the written statement? You said you have signed the written statement. So you are supposed to be aware of what is written in the written statement. So first you try to answer my question.
I am, at this moment, I don't remember what is this 5th December. What is the statement of 5th December 2008?
Shown paragraph 28.
Written statement.
On the no, my lord, of the plaint. Of the plaint. Because the witness says he doesn't remember what's there in the on that 5th December. shown paragraph 28 of the plaint, of the amended plaint. You will find there's the paragraph starting with that the plaintiff through its partner finally went.
পড়ে নিচ্ছি স্যার।
It is amended plaint.
17 of the amendment.
প্লেন্ট কোথায়? অ্যামেন্ডেড প্লেন্ট কোথায়?
Oh, না স্যার, পেজ প্যারাগ্রাফটা তো মিলবে। হ্যাঁ, তাই তো, সেটা হলেই তো। পেজ 17, amended plaint, পেজ 17, 17. হ্যাঁ, প্যারা 28 টা দেখান না। হ্যাঁ, ঠিকই তো আছে। তাহলে ওটা অরিজিনাল দেখাচ্ছে। ঠিক আছে, ডাজন্ট ম্যাটার।
I disagree.
Now, I have shown this. Now, would you now be in a position to answer the previous question?
Yes. একটু question পড়ুন। আমি reply দিয়ে দিচ্ছি। The question of this does not arise as the MOU was automatically cancelled with forfeiture of the amount on 15th of March 2005.
I put it to you that the agreement did not contemplate any automatic cancellation or forfeiture, and the defendant never forfeited, never exercised their right of forfeiture in terms of clause 4.3 of the said agreement, and your evidence with respect thereto is incorrect, false, and contrary to the records of this honorable court.
I disagree.
I further put it to you that since that in terms of your previous depositions, where you have stated that your association with the trust commenced from 2007, you do not have any personal knowledge of what happened in the year 2005 between the plaintiff and the trustees of the trust in terms of the agreement dated 28 January 2005.
I agree, but I heard it from then trustees as well as Mr. Ruya, who was joint secretary at that time and who is alive even now.
Would I be correct in saying that the plaintiff on 6th July 2009 had filed a suit before the Learned City Civil Court at Calcutta, which was registered as title suit number, which was registered against the trust seeking specific performance of the agreement dated 28th January 2005, which was registered as title suit number 5574 of 2008.
Yes, I have heard about it.
Have you also heard that in the said suit, an order was passed on 27th March, no, an order was passed on 6th July 2009, by which the learned City Civil Court at Calcutta was pleased to return the plaint to be presented before this honorable court?
Yes.
Would I be correct in saying that pursuant to the said order of the learned City Civil Court at Calcutta, the present suit being CS number 288 of 2014 is now being tried before this honorable court?
Sir, I am not that legal person, but it is, I would think it would be the, you have come here for the same suit.
But I think
You must be coming here for the same suit.
Shown tax payment shown page exhibit number ta bolo 33 এটা একটাই কি
yes sir.
exhibit
I collectively আছে third place
আই আর কি আছে দেখাও না এক্সিবিট আইটা একটু দেবেন কালেক্টিভলি আছে দেখুন এক্সিবিট আই একটা আছে না কালেক্টিভলি আছে
SCK SARIA.
I collective.
Yes.
Dinesh, DINESH.
এটা 30 এই দুটো পেজ তো আছে এই তো আই কালেক্টিভলি মানে দুটো পেজ দেখো 30 31 না 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 ওটা আগেরটা রিসিপ্টটা আগে
স্যার ট্যাক্স বিল আছে ট্যাক্স বিল
হ্যাঁ বলছি কোয়েশ্চেনটা করে হ্যাঁ Are these documents concerning property tax of the subject premises?
Yes, sir. They are.
Now, off premises number ta bole diye একবার off premises number টা বলো না written statement আছে প্রিন্টটা কোথায় গেল off kindly give me my lord kindly of premises number কত 1/1 Dakers Lane.
Yes, sir.
This is এটা exhibited sir M
দাঁড়াও অ্যাড্রেসটাই তো মিলছে
SERES.
অ্যাড্রেসটাই তো মিলছে না। কি বলছো
আম্বার হোটেলে ব্যাগে আছে
কোথায় আছে 1/1
How long would you take
Hello?
for finishing this cross-examination? Little bit more.
Take one more day.
So come on the next day.
Very well. Let this be the last question. I'll ask premises number টা লিখুন 1 James Hickey, Hickey, Sharoni, which has now been renumbered as সেটা কোথায় বলা আছে?
James Hickey.
Hickey, Hickey, James Hickey Sharoni. Which is what is the premises number now? The Deca's Lane আগে ছিল. The Deca's Lane used to be earlier.
Yes.
Nowadays, Deca has been renamed.
And one by one takers.
You come on the next date.
Very well. I'll ask this question on the next.
Because Deca's Lane was earlier name.
Yes.
এখন স্যার নম্বর আছে লেখাই বিলেই 1 জেমস হিকি সারনি লেখাই আছে।
That is renumbered. According to him, that was renumbered. What is that renumbered? That would be the question.
আগে 5 ডেকার্স লেন নম্বর ছিল স্যার।
But I think presently it is known as James Hickey Sharoni.
Yes, that might be from Deca. According to him, it was previously Deca's Lane.
Correct.
Now James Hickey Sharoni. So James Hickey Sharoni is not changed further.
No, it has not changed. He says.
Only number of the premises can be changed.
But I'm wondering who's James Hickey?
First editor of the newspaper.
Oh.
I cannot exactly remember.
Okay.
But he was the first editor of some newspaper.
Okay.
And he published a first newspaper in India or Kolkata.
স্যার একটু কথা বলতে পারি আপনাকে?
এইটি
স্যার আপনি আমার আগে যে কিছু कुछ बात होता था you asked the person कि একটু ব্যাকগ্রাউন্ড আমাকে দিয়ে দিন। এক वकील
For remembering.
For some case ও 28 কোটি টাকা 20 কোটি টাকা।
First, let you be cross-examined. I will hear the matter. I will hear argument of both the parties. Then I will decide the matter.
স্যার একটু জেনে নেবেন কেন এই ট্রাস্টে মামলা আছে আমার।
All right, but don't say this way. Definitely this court will know. And this court will know only to the extent evidence is adduced. Not going beyond the scope of evidence. If you think something is to be informed to this court, you can state it to this court. You have to adduce evidence or otherwise documentary. After, once the cross-examination is going on, you cannot say. You can explain only this court.
পরে বলবো।
পরের দিন বাকিটা করে দেবো।
When will you come?
Any day convenient to Lordship. Any day.
Did bolo.
Any day.
This question may be penned through.
Yeah. The last question may not go down. We'll ask that question. That property tax.
না জুলাই কেস কি শেষ করা হয়ে এসেছে।
হ্যাঁ।
27 June is okay? That previous witness,
My lord.
DW1, his examination of in chief was not complete.
Not complete.
That's why it was expunged.
Expunged.
Oh, no, not Thursday. Not Thursday. I have appellate side matters. No? 25? 25 hard DW1 is cross-examined in part. Further cross-examination is deferred to 25th.
Grateful, man.
If you want to volunteer something, you can say, I will record.
25th June. Very good.